Hey guys, welcome back to the KJMETHOD YouTube channel. Today we are on title transfer test review number 3. If you are just joining us, we started this series with contracts. We've probably done over 300 questions by now, so make sure to go back to the beginning there. For you guys that have been with me, don't forget to like, share, and subscribe. Thank you for continually coming back to the YouTube channel. And also, if you want a copy of that free study guide, don't forget to click the link below. As you know, we are interested in you understanding the topic, not just regurgitating it, because if you understand, you can answer any question that is presented to you. So let's get started. Number 21. In 2022, John puts his home on the market and he finds a buyer. John purchased the home in 1998. When a title search was done by the potential purchaser, it was discovered that in 2018 there was a judgment placed on the home because John didn't pay his visa bill. What would be the best way for John to have this problem corrected so that the buyer can move forward? A. Go to his title company and have them resolve the issue. B. Inform the title company that he paid the visa bill and show them proof. C. File a lawsuit against Visa for failing to inform John in a timely manner. Or D. He can pay the visa bill now, have Visa issue a document releasing the judgment. Well, what do you think? The test question is already telling us that John did not pay the visa bill. And so the best answer here would be for him to pay the visa bill now and then have Visa issue a document essentially releasing the judgment on the property. 22. Fatima sold a property to Delilah on 4/5. Delilah immediately left the closing and went on vacation for exactly 2 weeks. When Fatima noticed that Delilah had left without moving in, on 4/17, she resold the property to Mark. Mark decided to go over to the property to check it out and return to his old home to pack. Delilah returned from vacation on 4/19 and began having work done outside of the home to include landscaping, siding, exterior lighting, but she totally forgot that she needed to record her deed. On 4/23, Mark recorded his deed. Who owns the property? Again, one of these confusing timeline questions. You just gonna make a little timeline. Sold 4/5. On 4/17, sold again. On 4/19, what happened? Began landscaping and so forth on the property. 4/23, recording of the deed. So, A, who owns the property? Fatima, because there's no indication that any of the deeds are in writing. B, Mark, because he was the first to record the deed. C, Delilah, because she was the first to cultivate the land. D, Delilah, because although Mark recorded the deed first, she purchased the property first. So what's the rule here, guys? The rule here is who gave constructive notice first. When we are going like, who owns it? Who owns it? I want you to think, who gave constructive notice first? You could give constructive notice in 3 ways. You can move in first, you could record first, or you could cultivate the land first, which means doing activity at the house first. Okay? And so if you say that, who did one of those 3 things first? Well, Delilah, because Delilah on the 19th, before Mark recorded the deed on the 23rd, she began having work done. Landscaping, siding, blah, 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 and so forth. So she is the one that owns the property for your test. 23. Diane, a seller, gave a power of attorney to Dale, specifically authorizing him to go to her closing on Friday and transfer the deed. Dale signed the deed and delivered it to the grantee, Jim, at the closing. Jim accepted the deed and the money was wired into Diane's account, as per her instructions. Unbeknownst to Dale, though, Diane had died the night before the closing. Before he ever did anything, she died. Was there valid conveyance? A, yes. Dale had the power of attorney and properly executed and delivered the deed as per the instructions. B, yes, Dale's power of attorney was not revoked because he didn't have knowledge that Diane died before he executed the deed. C, no, because only a licensed attorney can transfer a deed, not a person given a power of attorney. And D, no, Dale's power of attorney terminated by operation of law, even though he didn't know Diane died. So what's the rule here? Well, D is the exact rule. So let's unpackage it. Guys, all of these test questions are there to confuse you. Yeah, there's a lot of stuff going on. So what are you looking for? Did Dale know that Diane died? No. Does Dale need to know Diane died? No, because here's the rule. All powers of attorney die when the person giving it or the person receiving it died. At the point of death, we don't need to know they died. So the fact that he didn't know Diane died does not matter. On Friday, when he went into that closing and Diane already died, none of the closing was valid. 24. Derek is selling his home. He signs the deed over to the buyer, but didn't have it notarized. In anticipation of closing, he gives it to his attorney, tells his attorney that he will meet him at the closing the next day. Derek dies that night, unbeknownst to anyone. Can his attorney complete the closing since the deed was already with the attorney? What do you think about this? A, no, the attorney cannot complete the closing because it must be delivered to the grantee while Derek is alive. B, yes, because the attorney had specific instructions from Derek. C, yes, because the attorney had no idea that Derek died. He can complete the closing. D, no, because the deed has to be notarized before transfer. Okay. This question could be confusing, right? Because what is the reason that this is going to be valid or invalid? So a lot of times you get these test questions, a person died. First of all, we don't need to know people died. There are laws in place that just say if you're dead, you're dead. Like nothing can transfer if you're dead, right? The transfer has to happen while you're alive. So don't get confused by that. So the best answer here is the attorney can't complete the transaction. Why is that though? Because he gave his attorney instructions on what to do, but he died before the transfer actually took place. Transfers must happen when the grantor is alive, unless we're transferring by will, okay? But in your test question, I guarantee you're going to get a test question that the grantor is alive and then he dies, okay? And so what is the effect of the transfer? Well, no transfer happens. So this is how I teach my students. I just want you to look for, at the point of death, who has the deed. If the deed has already been given to the other side, good transfer. If it hasn't been given to the other side, no, the transfer is not good. I don't care that he gave it to his attorney. That attorney cannot transfer the deed because at the point of death, it's no longer Derek's house anyway. Okay, so you can't transfer it based on Derek's wishes if it's not his house once he died. 25. Denzel has entered into a contract to purchase Dan's home. During the contract and prior to the closing, what is the status of the parties' relationship? A. Dan has legal title to the closing and the contract is executory until closing. B. Denzel has legal title until closing and the contract is executed until closing. C. Dan has equitable title till closing and the contract is executed until closing. Denzel has equitable title until closing and the contract is executed until closing. Well, this has a lot of words in it, but it's pretty easy because a contract is executory until closing. This is a quick way to answer certain questions. So me looking at this, B, C, and D say the contract is executed until closing. It's always executory until closing, so it's gonna be A, even if you didn't know who has legal, who has equitable. But in this case, Dan, of course, continues to have legal title until the closing. But between contract and closing, it's executory. 26. Delia is selling her home to David, who happens to be a minor, but who just won $2 million in the lottery. Go David. Delia signs the deed over to David, and David moves into the property. A month after closing, Delia wants to declare the sale void and states that the deed was invalid because minors cannot be grantees. Will Delia be able to get out of the transaction? A, yes, because minors cannot be grantees to property. B, yes, because a deed granted to a minor is void. C, no, because minors can be grantees, but the closing happened too long ago. And D, no, because minors can be grantees, and only the minor can void the contract. Yeah, there's two things happening here. Her claim is terrible, right? Her claim is terrible. It's going to be D, because minors can be grantees. Don't forget, the grantor can't be a minor, but the grantee can be a minor. And then also, can she be the one that's mad about it? No, because if it is able to be voidable, if it's able to be voided, it would only be able to be done by the minor, not by Delia. Number 27. Which of the following best describes the main purpose of recording a deed in the public record? You guys should know this one. A, to make the transfer of title legally valid. B, to notify the grantor that the transfer is complete. C, to provide constructive notice of ownership to third parties. And D, to guarantee that the title is free of liens and encumbrance. Well, again, of course it's C, to provide constructive notice of ownership. Again, let's go over it. You do not need to record anything. It's not required by law. Is it a good idea to record? Yes, it is. We record for two reasons. We record for priority and we record for constructive notice, not actual notice, constructive notice. So we're giving people notice that we have a claim in the property. Number 28. Which of the following is considered an essential element of a valid deed? A, the deed must be recorded within 30 days of delivery. Hopefully you're not picking that answer anymore. B, the deed must contain words of conveyance. C, the deed must be signed by both the grantor and the grantee. And D, the deed must specify the exact amount of consideration in dollars. Well, the correct answer here is B. Hopefully you know deeds don't have to be recorded. Hopefully you know that only the grantor signs the deed. And the one that you may not have been sure about is the exact amount of consideration. Deeds do require consideration, but the exact amount does not have to be placed in there. That's why if you've ever seen a deed before, it may say in consideration of $1, because we don't care what amount you put in there. We just state that there is some consideration. However, the granting clause, which is the clause that tells us exactly what you're giving to the person, must be in there. Don't forget, you can give them the house, you can give them a life estate, you can give them an easement. So that has to be included. 29. A buyer's purchase contract states that closing is contingent upon the buyer obtaining financing within 30 days. If the buyer cannot secure financing, what happens to the transfer of title? A, title automatically passes to the buyer because the contract was signed. B, the seller must transfer title but can sue the buyer later for damages. C, the contingency prevents title from transferring until the financing condition is satisfied. D, the deed must still be delivered, but the buyer may rescind later. Guys, contingency is exactly what it says. This can't happen until this contingency is cleared. Financing contingency. We can't transfer the deed until you obtain financing. So the correct answer is C. Number 30, an attorney handling a closing for Mr. and Mrs. Jones sends a title researcher to the local county courthouse to examine the title on the home the Jones are purchasing. After the attorney receives the information, he writes a report to the title company giving a rendition of the title documents that were on file. This opinion from the attorney is called what? A, the chain of title. B, the abstract of title. C, color of title. Or D, cloud on title. Well, this is pure definition. This one would just be called B, abstract of title. All right, that is it on title transfer test review number 3. And that's also it on title transfer. It's a very specific topic. All right, I'm KJ from the KJ Method. Don't forget to tell all your friends, and also click the link below if you want a copy of that free study plan. We're coming back with another section. So make sure that you are understanding, not just going through these questions. And if you're new, like I said, start back at contracts and come all the way forward. See you guys the next time.
Jumpstart your real estate career with KJ Method. Pass the exam with